The sharing of waters of the Kaveri River has been the source of a serious conflict between the Indian states of Karnataka and Tamil Nadu. The genesis of this conflict rests in two agreements in 1892 and 1924 between the erstwhile Madras Presidency and princely state of Mysore. The 802 kilometres Kaveri River has 44,000 km2 basin area in Tamil Nadu and 32,000 km2 basin area in Karnataka. Karnataka contends that it does not receive its due share of water from the river. It claims that the agreements were skewed heavily in favour of the Madras Presidency, and has demanded a renegotiated settlement based on equitable sharing of the waters. Tamil Nadu, on the other hand, pleads that it has already developed almost 3 million acres of land and as a result has come to depend very heavily on the existing pattern of usage. Any change in this pattern, it says, will adversely affect the livelihood of millions of farmers in the state. Decades of negotiations between the parties bore no fruit. The Government of India then constituted a tribunal in 1990 to look into the matter. After hearing arguments of all the parties involved for the next 16 years, the tribunal delivered its final verdict on February 5, 2007. In its verdict, the tribunal allocated 419 billion FTA cubed of water annually to Tamil Nadu and 270 billion FTA cubed to Karnataka. 30 billion FTA cubed of Kaveri River water to Kerala and 7 billion FTA cubed to Puducherry. The dispute, however, appears not to have concluded, as all four states deciding to file review petitions seeking clarifications and possible renegotiation of the order. History of the dispute: the British controlled both Mysore and Madras for a short period in the middle of the 19th century. During their regime, numerous plans were drawn up for the utilisation of the Kaveri waters by both states. However, the drought and subsequent famine in the mid-1870s put a hold on the implementation of these plans. The plans were revived by Mysore in 1881, by which time Mysore was back in the hands of the Mysore kings, while present-day Tamil Nadu continued to remain a part of the Madras Presidency. Mysore's plans to revive the irrigation projects met with resistance from the Madras Presidency. Mysore state made a representation to the then British government. As a result of which, a conference was held in 1890 with the objective of agreeing on the principles of a modus vivendi, which would on the one hand allow to Mysore in dealing with irrigation works, and on the other, give to Madras practical security against injury to interests, and eventually the agreement of 1892 was signed. Things came to a head in 1910 when Mysore, under Nalvadi Krishna Rajawadya as the king and Sir M. Visvesvaraya as chief engineer, came up with a plan to construct a dam at Kannambedi village to hold up to 41.5 TMC of water. The dam was planned to be built in 2 stages. In the first stage a capacity of 11 TMC was envisioned, while in the second stage the full capacity was set to be realized. Madras, however, refused to give its consent for this move as it had its own plans to build a storage dam at Metta with a capacity of 80 TMC. After a reference to the Government of India, permission was accorded to Mysore, but for a reduced storage of 11 TMC. During construction, however, the foundation was laid to suit the earlier desired full storage. This raised Madras hackles and the dispute continued. As a result, the then British Government of India referred the matter to arbitration under Rule 4 of the 1892 agreement. The Kaveri dispute thus had come up for arbitration for the first time. Sir H. D. Griffin was appointed arbitrator and M. Nethersole, the Inspector General of Irrigation in India, was made the assessor. They entered into proceedings on July 16, 1913 and the award was given on May 12, 1914. The award upheld the earlier decision of the Government of India and allowed Mysore to go ahead with the construction of the dam up to 11 TMC. Madras appealed against the award and negotiations continued. Eventually an agreement was arrived at in 1924 and a couple of minor agreements were also signed in 1929 and 1933. The 1924 agreement was set to lapse after a run of 50 years. Post-independence developments: in 1947, India won independence from the British. Further in 1956, The reorganization of the states of India took place and state boundaries were redrawn based on linguistic demographics. Kodagu or Kog became a part of Mysore state. Huge parts of erstwhile Hyderabad state and Bombay Presidency joined with Mysore state. Parts of Malabar which earlier formed part of Madras Presidency went to Kerala. Puducherry had already become a de facto union territory in 1954. All these changes further changed the equations as Kerala and Puducherry also jumped into the fray. Kerala staked its claim as one of the major tributaries of the Kaveri, the Kabini, now originated in Kerala. The Karaikal region of Puducherry at the tail end of the river demanded the waters that it had always used for drinking and some minimal agriculture. While these additional claims complicated matters greatly at a technical level, Mysore state and Tamil Nadu still remain the major parties to the dispute. By the late 1960s, both states and the central government began to realize the gravity of the situation as the 50-year run of the 1924 agreement was soon coming to an end. Negotiations were started in right earnest and discussions continued for almost 10 years. 1970s, while discussions continued, a Kaveri fact-finding committee was constituted. The brief of the CFFC was to inspect the ground realities and come up with a report. The CFFC came up with a preliminary report in 1972 and a final report in 1973. Inter-state discussions were held based on this report. Finally in 1974, a draft agreement which also provided for the creation of a Kaveri Valley Authority was prepared by the Ministry of Irrigation. This draft, however, was not ratified. In 1976, after a series of discussions between the two states and the central government chaired by Jagjeevan Ram, the then irrigation minister, a final draft was prepared based on findings of the CFFC. This draft was accepted by all states and the government also made an announcement to that effect in Parliament. When Karnataka began construction of the Harangi Dam at Kushalanagar in Kodagu, it was once again met with resistance from Tamil Nadu. Tamil Nadu went to court demanding the constitution of a tribunal under the Interstate River Water Disputes Act of 1956. It also demanded the immediate stoppage of construction work at the dam site. In spite of this, Karnataka went for completion of the dam without taking into account the impact on the livelihood of other states. 1980s, later Tamil Nadu withdrew its case demanding the constitution of a tribunal and the two states started negotiating again. Several rounds of discussions were held in the 1980s. The result was still a stalemate. In 1986, a farmer unregistered trademark association from Tanjavur in Tamil Nadu moved the Supreme Court demanding the constitution of a tribunal. While this case was still pending, the two states continued many rounds of talks. This continued till April 1990 and yet yielded no results. The constitution of the tribunal, the Supreme Court then directed the government headed by Prime Minister V.P. Singh to constitute a tribunal and refer all disputes to it. A three-man tribunal was thus constituted on June 2, 1990. The tribunal was headquartered at New Delhi and was to be headed by Justice Chitatosh Mukherjee. The four states presented their demands to the tribunal as under. Karnataka claimed 465 billion FTA cubed as its share, Kerala claimed 99.8 billion FTA cubed as its share, Puducherry claimed 9.3 billion FTA cubed, Tamil Nadu claimed the flows should be ensured in accordance with the terms of the agreements of 1892 and 1924 for Tamil Nadu and Puducherry. 177 billion FTA cubed for Karnataka and 5 billion FTA cubed for Kerala. Interim award and the riots. Soon after the tribunal was set up, Tamil Nadu demanded a mandatory injunction on Karnataka for the immediate release of water and other reliefs. This was dismissed by the tribunal. Tamil Nadu now went back to the Supreme Court which directed the tribunal to reconsider Tamil Nadu unregistered trademark's plea. The tribunal reconsidered Tamil Nadu unregistered trademark's plea and gave an interim award on June 25, 1991. In coming up with this award, The tribunal calculated the average inflows into Tamil Nadu over a period of 10 years between 1980 €81 and 1989 €90. The extreme years were ignored for this calculation. The average worked out to 205 billion FTA cubed, which Karnataka had to ensure reached Tamil Nadu in a water year. The award also stipulated the weekly and monthly flows to be ensured by Karnataka for each month of the water year. The tribunal further directed Karnataka not to increase its irrigated land area from the existing 1,120,000 acres. Karnataka deemed this extremely inimical to its interests and issued an ordinance seeking to annul the Tribunal unregistered trademark S award. The Supreme Court now stepped in at the Presidente unregistered trademark S instance and struck down the ordinance issued by Karnataka. It upheld the Tribunal unregistered trademark S award, which was subsequently gazetted by the Government of India on December 11, 1991. Karnataka was thus forced to accept the interim award, and widespread demonstrations and violence broke out in parts of Karnataka and Tamil Nadu following this. Thousands of Tamil families had to flee from Bangalore in fear of being attacked and lynched by pro-Canada activists with the behest of the state government. The violence and showdown, mostly centered in the Tamil-populated parts of Bangalore, lasted for nearly a month, and most schools and educational institutions in Bangalore remained closed during this period. The crisis of 1995–1996. In 1995, the monsoons failed badly in Karnataka and the state found itself hard-pressed to fulfill the interim order. Tamil Nadu approached the Supreme Court demanding the immediate release of at least 30 billion FTA cubed. The Supreme Court refused to entertain Tamil Nadu's petition and asked it to approach the tribunal. The tribunal examined the case and recommended that Karnataka release 11 billion FTA cubed. Karnataka pleaded that 11 billion FTA cubed was unimplementable in the circumstances that existed then. Tamil Nadu now went back to the Supreme Court demanding that Karnataka be forced to obey the tribunal's order. The Supreme Court this time recommended that the then Prime Minister, P.V. Narasimha Rao, intervene and find a political solution. The Prime Minister convened a meeting with the Chief Ministers of the two states and recommended that Karnataka release 6 billion FTA cubed instead of the 11 billion FTA cubed that the tribunal ordered. Karnataka complied with the decision of the Prime Minister and the issue blew over. Constitution of the CRA. Karnataka had all through maintained that the interim award was not scientific and was inherently flawed. It had, nevertheless, complied with the order except during 1995–96 when rains failed. What complicated matters was that the interim award was ambiguous on distress sharing and there was no clear-cut formula that everyone agreed upon to share the waters in the case of failure of the monsoon. In 1997, the government proposed the setting up of a Kaveri River Authority which would be vested with far-reaching powers to ensure the implementation of the interim order. These powers included the power to take over the control of dams in the event of the interim order not being honored. Karnataka, which had always maintained that the interim order had no scientific basis and was intrinsically flawed, strongly protested the proposal to set up such an authority. The government then made several modifications to the powers of the authority and came up with a new proposal. The new proposal greatly reduced the executive powers of the authority. The power to take over control of dams was also done away with. Under this new proposal, the government set up two new bodies, viz., Kaveri River Authority and Kaveri Monitoring Committee. The Kaveri River Authority would consist of the Prime Minister and the Chief Ministers of all four states and was headquartered in New Delhi. The Kaveri Monitoring Committee, on the other hand, was an expert body which consisted of engineers, technocrats and other officers who would take stock of the ground realities and report to the government. The flare-up and high drama of 2002, in the summer of 2002, things once again came to a head as the monsoon failed in both Karnataka and Tamil Nadu. Reservoirs in both states fell to record low levels and inevitably tempers rose. The sticking point yet again, as in 1995–96, was how the distress would be shared between the two states. The tribunal had overlooked this crucial point when it gave the interim award and it had returned once again to haunt the situation. Tamil Nadu demanded that Karnataka honour the interim award and release to Tamil Nadu its proportionate share. Karnataka on the other hand stated that the water levels were hardly enough to meet its own demands and ruled out releasing any water in the circumstances that prevailed. CRA meeting and the Supreme Court order. A meeting of the Kaveri River Authority was called on August 27 but the Karnataka Chief Minister walked out of the meeting. The focus now shifted to the Supreme Court which ordered Karnataka to release 1.25 billion FTA cubed of water every day unless the Kaveri River Authority revised it. Karnataka was forced to release water but pressed for another meeting of the Kaveri River Authority which was fixed for September 8. The Tamil Nadu Chief Minister this time boycotted the meet citing insufficient notice as the reason. A minister from her cabinet, however, represented Tamil Nadu. The Kaveri River Authority revised the court's order from 1.25 billion FTA cubed to 0.8 billion FTA cubed per day. This time however, the Karnataka government in open defiance of the order of the Kaveri River Authority, refused to release any water succumbing to the large-scale protests that had mounted in the Kaveri districts of the state. Tamil Nadu, aghast at the defiance, went back to the Supreme Court. Karnataka now resumed the release of water for a few days, but stopped it again on September 18 as a Karnataka farmers in their protests threatened to take a dangerous turn. The centre now stepped in and asked Karnataka to release the water. The Supreme Court meanwhile, in response to Tamil Nadu's petition, asked the Kaveri River Authority for details of the water release and water levels in the reservoirs. Demonstrations, the flare-up had by now, well and truly taken an ugly turn and there were accusations and counter-accusations being thrown all around in both states. The dispute had already spilled onto the streets in the Mandya district of Karnataka and was threatening to spread to other parts of the state too. Precipitating the matters on the streets, the Supreme Court ordered Karnataka on October 3 to comply with the Kaveri River Authority and resume the release of water. Karnataka once again refused to obey the orders of the Supreme Court. Tamil Nadu filed another contempt petition on Karnataka and soon the issue degenerated into a free-for-all with all and sundry from both states joining the protests. Soon, film actors and various other cross-sections of society from both states were on the streets. Tamil TV channels and screening of Tamil films were blocked in Karnataka. Also all buses and vehicles from Tamil Nadu were barred from entering Karnataka. The Karnataka Chief Minister, S.M. Krishna on the other hand, fearing that the situation might spiral out of control, embarked on a padayatra from Bangalore to Mandya. While some saw this as merely a gimmick, some, like U. R. Ananthamurthy, saw it as a good faith effort to soothe tempers and joined him in the yatra. 2003–2006, this period did not see any major flare-up in the dispute even though the summer of 2003 saw a dry spell in both states. The monsoons in 2004, 2005 and 2006 was quite copious and this helped a great deal in keeping the tempers calm. While the last 3 or 4 years have been relatively quiet as far as jingoistic voices are concerned, a flurry of development has been afoot in the courts. The term of the tribunal was initially set to expire in August 2005. However, in the light of the many arguments the court was yet to hear, the tribunal filed a request for extension of its term. The extension was granted and the tribunal's term was extended for another year until September 2006. Early in 2006, a major controversy erupted over the assessor's report that was apparently leaked to the press. The report had suggested a decision which Karnataka summarily rejected. Another major controversy erupted when just a couple of months before the September 2006 deadline, the tribunal recommended the formation of another expert committee to study the ground realities yet again. This was unanimously and vehemently opposed by all the 4 states party to the dispute. The states contended that this move would further delay a judgment which has already been 16 years in the making. More than the disapproval of all the 4 states of the new expert committee that was proposed, the proposal turned out to be a major embarrassment for the tribunal. This was because, not only were the 4 states opposed to it, even the chief judge of the tribunal was opposed to it. However, the other 2 assistant judges on 3-man adjudication team, overruled the opinion of the main judge. and all this was done in a packed courtroom, and this led to petty bickering and heated arguments between the three judges in the packed courtroom. This left everyone in the courtroom shocked, and the Tamil Nadu Council was moved to remark that it was embarrassing that the judges probably needed help settling their own disputes before adjudicating on the dispute at hand. Nonetheless, the new expert committee was formed and carried out further assessments. Subsequently, the extended deadline of the tribunal also passed, and the tribunal was given yet another extension. 2007, Judgment. The Kaveri Water Disputes Tribunal announced its final verdict on February 5, 2007. According to its verdict, Tamil Nadu gets 419 billion FTA cubed of Kaveri water, while Karnataka gets 270 billion FTA cubed. The actual release of water by Karnataka to Tamil Nadu is to be 192 billion FTA cubed annually. Further, Kerala will get 30 billion FTA cubed and Puducherry 7 billion FTA cubed. Tamil Nadu and Karnataka, unhappy with the decision, filed a revision petition before the tribunal seeking a review. 2011, Reports on Water Situation in Tamil Nadu, Professor S. Janakarajan, from Madras Institute of Development Studies, Tamil Nadu, submitted a report to the India Water Portal, in December 2011, on the increasing levels of water pollution in Tamil Nadu. The rivers of Kam River, Adur River, Pala River, Kaveri etc., with high levels of water pollution, due to sewage and industrial effluents, led Tamil Nadu towards severe water shortage. The Pala River was ranked the world's third most polluted river, by the Blacksmith Institute in 2006. Such factors stem similar Kaveri River drinking water dispute between Tamil Nadu and Kerala. 2012. On September 19, 2012, Prime Minister Manmohan Singh, who is also the chairman of the Kaveri River Authority, directed Karnataka to release 9,000 cubics of Kaveri water to Tamil Nadu at Bilagundla daily. But Karnataka felt that this was impractical due to the drought conditions prevailing because of the failed monsoon. Karnataka then walked out of the high-level meeting as a sign of protest. On September 21, Karnataka filed a petition before the Kaveri River Authority seeking review of its September 19 ruling. On September 24, Tamil Nadu's Chief Minister directed the officials to immediately file a petition in the Supreme Court seeking a direction to Karnataka to release Tamil Nadu its due share of water. On September 28, 2012, the Supreme Court slammed the Karnataka government for failing to comply with the directive of the Kaveri River Authority. Left with no other option, Karnataka started releasing water. This led to wide protests and violence in Karnataka. On October 4, 2012, the Karnataka government filed a review petition before the Supreme Court seeking a stay on its September 28 order directing it to release 9,000 cubics of Kaveri water every day to Tamil Nadu, until October 15. On October 6, 2012, several Kannada organizations, under the banner of a OE Kannada Kuta Euro, called a Karnataka band on October 6 in protest against the Kaveri water release. On October 8, the Supreme Court of India announced the release of 9,000 cubics has to be continued, and it is up to the Kaveri River Authority's head, the Prime Minister, as a responsible person, to ensure this happened. The Prime Minister ruled out a review of the Kaveri River Authority Euro unregistered trademark's decision until October 20, rejecting the plea by both the Congress and Bharatiya Janata Party leaders from Karnataka. Within a few hours, Karnataka stopped release of Kaveri water to Tamil Nadu. On October 9, 2012, Tamil Nadu's Chief Minister directed authorities to immediately file a contempt petition against the Karnataka government for flouting the verdict of the Supreme Court by unilaterally stopping the release of water to Tamil Nadu. Tamil Nadu made a fresh plea in the Supreme Court on October 17, reiterating its demand for appropriate directions to be issued to Karnataka to make good the shortfall of 48 TMCFT of water as per the distress sharing formula. On November 15, 2012, the Kaveri Monitoring Committee directed the Karnataka government to release 4.81 TMCFT to Tamil Nadu between 16 and 30 November. On December 6, the Supreme Court directed Karnataka to release 10,000 cuses of water to Tamil Nadu. The court asked the union government to indicate the time frame within which the final decision of the Kaveri Water Dispute Tribunal, which was given in February 2007, was to be notified. This decision was given in the view of saving the standing crops of both the states. Indian government notifies Kaveri Water Dispute Tribunal, on February 20, 2013, based on the directions of the Supreme Court. The Indian government has notified the final award of the Kaveri Water Disputes Tribunal on sharing the waters of the Kaveri system among the basin states of Karnataka, Tamil Nadu, and Kerala and Union Territory of Puducherry. The A-OE Extraordinaire notification in the Gazette dated February 19, 2013 says the order takes effect on the date of publication. The tribunal, in a unanimous decision in 2007, determined the total availability of water in the Kaveri Basin at 740,000 million cubic feet at the lower Kulru-Nanikat site, including 14 TMCFT for environmental protection and seepage into the sea. The final award makes an annual allocation of 419 TMCFT to Tamil Nadu in the entire Kaveri Basin, 270 TMCFT to Karnataka, 30 TMCFT to Kerala and 7 TMCFT to Puducherry. Temporary Supervisory Committee, in response to the special leave petition lodged by Tamil Nadu earlier, the Supreme Court on May 10, 2013 issued an interim direction to the Government of India to establish a temporary supervisory committee to implement the Kaveri Tribunal order till the constitution of a OE Kaveri Management Board was stated in the tribunal order. Goa issued the Gazette notification on May 22, 2013 establishing the said supervisory committee. See also, Kaveri River, Right to Water, Water Rights, Krishna Water Disputes Tribunal, Godavari Water Disputes Tribunal, Interstate River Water Disputes Act, Indian Rivers Interlink, References. Further reading, Kaveri Water Dispute. Rediff.com. Janakarajan, J. Breaking the Kaveri Deadlock. The Hindu. Thacker, Himanshu. Why the Kaveri Award is Flawed. Rediff.com. Thacker, Himanshu. Kaveri Tribunal Award 2007, Why it Fails the Tests of Science, Efficiency and Equity. South Asia Network on Dams, Rivers and People.